I call Chris Penk.
Thank you, Madam Speaker, for the opportunity to join others on both sides of the House in commending the Coroners' Access to Body of Dead Person Amendment Bill in this, the third and final reading. We've heard from others with experience in the professional sphere, and I acknowledge Haritihi Pango, those with personal stories, and I acknowledge the Honourable Shane Jones, who gave a couple of moving accounts from recent and past experiences in his whānau and connections that he has had, and also the procedural, and I acknowledge the outline of the history of this bill coming to this place by Marama Davidson. Ma'am, my own perspective will be briefly historical, and also with some thoughts about some philosophy about the relationship between the state and its citizens as reflected in this very helpful amendment to our statute book. The word coroner literally means an officer of the Crown, going back to the days when in the Anglo-Norman phase of English history, the coroners, as they became known, were responsible for collecting local records of proceedings in which the Crown had jurisdiction, also collecting certain revenues and, relevant to the modern function of course, investigating suspicious deaths. And it was in that latter, as well as the other types of function, that it was acknowledged then, and perhaps more so now, that the awesome power of the state over its citizens should be exercised in a way that is, reflects the seriousness of the role that they carry out, but is also sensitive to the rights of subjects. And of course, we are talking about a balance in this piece of legislation, and more particularly in the amendment that's before us now, in understanding that coroners have an important function, both in medical terms and in legal terms, but also needing, of course, to understand the sensitivities around the cultural considerations, in particular, that arise when circumstances of a person being dead do arise and need to be taken into account. I'll just pause briefly for a moment, Madam Speaker, to note that in legal terms, a dead person is not a person, and of course, by definition, a person is a living person and has human rights on that basis, but that's something of a legal fiction, because, of course, a recently deceased person, and indeed maybe a person throughout time immemorial, according to the beliefs of some, will always be a person and not merely in that moment that they've recently deceased a collection of human tissue or merely cells and so forth. And so from a cultural perspective, of course, that person is indeed very much still a member of a family, a whānau, and so on. And so it is important that, notwithstanding that legal fiction about the status of the physical body, in fact, we do need to be sensitive to the dignity of that person, and also, of course, the loved ones who are left behind, and in particular, in circumstances where a coronial investigation would be underway, naturally there would be oftentimes circumstances to imagine that the stress and the grieving would be particularly heightened. And so it's balancing these practical, pragmatic considerations of the legal and medical aspects to learn the lessons, but also perhaps to prepare, in some cases, sadly, for a criminal context to understanding the circumstances, balanced against the human needs of that person themselves and their family and whānau that this piece of legislation seeks to achieve. And that balance, I think, is well reflected in the fact that we talk in the new, what will be the new section 26, ethnic origins, social attitudes or customs or spiritual beliefs and so forth. That seems to me appropriate, as does the giving of an example whereby the right of persons to view, touch or remain with or near the body, for example, the customary requirement under tikanga Māori. And that seems to me an appropriate example because it reflects, as is the case in this country, something of a first among equals status, whereby we acknowledge that in many cases for whānau it will be particularly significant for this right for these considerations to be taken into account, but also understanding that other ethnic and spiritual and religious and cultural considerations will mean that others too feel a particular need to be able to do these things and to grieve in a way that's appropriate to them. These are considerations that are to be taken into account now. That seems to me entirely appropriate. The coroner will be able to do what he or she needs to be able to do, but taking into account this sensitivity, understanding that the power of the state is to be exercised in that way seems entirely appropriate. And so, with no further hesitation, Madam Speaker, I'm pleased to join others among the assembled contributors to this debate in the House in commending this bill to the House.
Madam Speaker.
I understand this is a split call. I call Jan Tinetti.
Thank you. Thank you, Madam Speaker. I remember speaking on this bill in